on things, but I'm going on mute and stop video now. So I'd say if you guys want to get started, it's perfectly fine.
Okay. Denise, do you want to get started and roll with it then?
Yes, as soon as I figure out. Okay, I'm thinking it's recording. Okay, good. Recording is in progress.
Perfect. Thanks, guys. Enjoy.
Okay, well, hi everybody, and this is all very interesting doing this virtual. So please be patient with us. But I've done a couple of these virtual trainings so far, and none of them have been total disasters. So I'm optimistic. So I know most of you. My name is Denise Metz, and I am the supervisor of the sex offender team here at Boulder Probation. I've been working with sex offenders, since 2005, and I've been with the state probation here in Boulder for about 20 years.
And I'm Gary Reeser. Kind of like Denise and I got started about the same time, 2005. I'm in private practice. I'm the owner and clinical director for Forensic Evaluation and Treatment Services. We have offices kind of from Denver, Boulder, Longmont, Greeley, kind of all over the place. And so, yeah, I look forward to this training. It's kind of amazing. I looked over and I've had almost 2,000 clients over all these years that I've worked with. So I also participate with the SOMB on the best practices committee. So anyway, look forward to sharing what we have to say today.
What do we have to say today? Well, this is our agenda, and I have to warn you, this is a presentation that Gary and I gave last at the SOMB conference back in 2019. And I did a little mini version of this to the judges back in 2019 as well, the judges here in Boulder. We're going to go through the first few slides pretty quickly. Those were more, I would say, geared for probation officers and therapists. Hopefully you attorney type will at least find it a little interesting. But we're going to talk about kind of some of the philosophical changes in the sex offender world, which are really underpinning the changes that we're going to talk about more in depth in the SOMB standards and guidelines, as well as the changes in the terms and conditions. And we're going to touch on the Allman case and appeal cases. I know those seem to be a little kind of hot topics right now. And then maybe even mention briefly, I don't even know if I'm saying this right, the Ellebrecht case. So, yeah, that's what we're going to do. Okay, regarding the philosophical changes, some of you, I think, have been around long enough to know that in the sex offender world, we used to have the containment model, and the no cure philosophy was written into the Sex Offender Management Board standards and guidelines. Those things are removed from the standards and guidelines. There's no more containment model. We operate under the TEAMS model, and we're going to talk more about that later. Also, as you guys know, we've moved far away from the absolutely no contact with your kids, including your own kids. You know, back in the day, we had the PRA. That's really long ago, the parental risk assessment. Then we moved to contact assessment, and now we have a contact screen. But it's really because of the Burns case that I'm sure all of you guys know way more about than I do. That's why most clients are now allowed to have contact with their biological children or children over whom they were in a parental role if they weren't victims. We've also moved away from this let's restrict everything and anything philosophy, and the paradigm has moved towards the Good Lives model, and we use something called a pro-social living plan, and we really want our clients to be involved in pro-social healthy activities. And we know a lot about if someone's isolated and under house arrest for months upon months. I mean, that's not really going to help us achieve the goal of helping the clients progress, and really is not helping community safety either. We're trying to move away, and I think we've done a very good job. It's not 100%, but moving away from the cookie cutter, everything applies to everybody approach. And we're using risk, needs, and responsivity. We're going to talk a little bit more about that, and trying to customize and individualize supervision to what extent we can, and certainly treatment to the individual. Not everything doesn't apply to everybody. And the last one, I don't think in Boulder we ever had a law enforcement approach. I'm a little biased, of course, but I think there's been an emphasis placed on building relationships with our clients, and how important to a client's success that relationship is with the therapist, but with the supervising probation officer. So, yeah, let's see. Gary?
Oh yeah, so let's talk just a little bit about the R&R stuff. It probably pertains more to treatment than anybody else, but I think it's important as attorneys that at least have a little bit of a vocabulary working with this. So R&R stands for risk, needs, responsivity, and it's more of an overarching philosophy than it is a prescription or a protocol. It doesn't really tell us how to do treatment. It doesn't really tell us how to do supervision, but what it says to us is to consider these three things whenever you're doing treatment, whenever you're making decisions, and essentially to look at the risk of a client, the needs. Now, it's kind of interesting about the need principle. Criminogenic needs is what they're talking about here, but they're really risk factors, and so we're supposed to focus on risk factors. And I don't really know exactly why they changed it from risk factors to needs, except if it had been risk factors, it would have been the RRR. So I think maybe they were thinking too many pirates involved, so they changed the acronym a little bit. Probably the biggest thing about this is that it just gives you a lot of flexibility to do what you need to do, keeping in mind that we're supposed to be risk oriented, that we are focusing on risk factors, not to get sidetracked on other things that are happening. And then also probably the biggest one, we'll talk about this a little bit later, is the responsivity, which has to do with the person's their learning style, their cultural, their backgrounds, I think one of the biggest ones is a person's childhood. A lot of our clients with traumatic childhoods, so that is a big factor. So let's see, let's go over to the next slide, which is implications. I mean, so if you apply these R&R principles, how does it change things? Well, the risk principle, it used to be that in treatment, you'd have clients in for a long time, and it didn't really matter what their risk was. It was kind of a one size fits all. The standards now promote or enforce the idea that people with higher risk get more dosage, people with lower risk get lower dosage. So we really do need to have an individualized plan and have it time limited so that we don't overtreat people. The criminogenic needs, we're supposed to use evidence-based risk factors, and depending on which researcher you use, there's a variety of different risk factors. They do kind of meld together into a similar format, but then as a treatment provider, we're supposed to be focusing on just those risk factors that applied to this particular person's offense. And again, the responsivity piece is that not, the bullet there, not all clients are equal. that we are to look at each individual client and adapt our protocols, adapt our treatment plan based upon their individual needs. So in practicality then, let's see, Denise, let's go to the next one. Yeah, what does this mean? Well, the research shows that you're not supposed to mix high risk and low risk clients. And so because that actually causes low risk clients to increase their risk. We try to, as much as possible, to segregate clients into contact and non-contact offenses. That's not always possible, just because of the size of the groups and how many people each treatment provider would have. But the idea is to have individualized plans individualized treatment plans based upon each person's specific needs. We have a thing called YAMP, that's the Young Adult Modification Protocol. Research has shown that people's cognitive functions don't fully develop until you're in your 20s. And so there are adjustments, and this is a responsivity factor, just a person's age would indicate that. And so the standards give us the ability to make modifications to the standards based upon a person's age. And then, of course, treatment needs. With a really good risk assessment and looking at risk factors, we look at both risk factors and protective factors. And so we try to strengthen a person's protective factors to offset for their risk factors. Again, there's a wide range of treatment needs, and in sex offense treatment, we're trying to do all of these things, although sometimes we do have to refer out for specific cases. R&R also applies to the incentives and sanctions, and Denise, I'll let you, that falls more on a probation side than it does treatment.
Yeah, and how we use R&R with incentives and sanctions, really, it's just we're trying to not overreact. We're trying to match the violation. And we're not going to arrest someone for looking at porn, for example, if they're not allowed to look at porn. That is, that would be a violation. But it's certainly, we want to make sure they meet the same level, and also that trying to customize and individualize the sanctions and incentives as well for each specific client, because what is meaningful to one client may not be meaningful to another. In terms of the CST decision making on cases, Gary and we have a monthly staffing with all the POs on my team and then Gary's team. And I can guarantee you for a couple hours every month, we're always talking, when we're talking about clients and, problem solving and decision making and helping the CSTs kind of do that process. We're always throwing out R&R stuff, R&R questions, and going back to risk and needs. So it's really a constant conversation amongst all the members. And of course, the implementation of R&R, there was an attempt to, I don't know if judicial had risk, needs, and responsivity at the top of their brains, but really what the new terms and conditions are doing is trying to get away from that cookie cutter approach and trying to customize things more. So, yes. That being said, the system isn't perfect in regards to utilizing R&R, which we're stuck in some ways with SOISP, for example, which, as you guys know, you attorney types are way more knowledgeable about this than I am, but SOISP is only for felony sex offenders. And just because somebody did a felony sex offender behavior, and that's what they plead guilty to, doesn't mean they're the highest risk person in terms of our risk assessments. So that can lead to situations where we have a low or moderate risk offender, and they are on SOISP, which dictates how often probation has to see them. So those are clients who start off, we're seeing them, 6 to 8 times a month. and seeing them or talking with the therapist or doing other collateral contacts. So there's a lot that goes into someone who's placed onto SOISP, which may not be 100% congruent with their risk level. So, and I do understand, of course, there's reasons for all of that statutory. But the fact is that sometimes it feels like we over supervise, but what's happened with the SOISP phases, I think most of you probably know we have phases to SOISP, phase 1, phase 2, phase 3, that the CST has the ability to move clients through those 3 phases without any court intervention. But then if we want to move somebody from SOISP off to non-SOISP terms and conditions, we actually have to file a motion and do victim notification and all that good stuff. So we're able to move the clients more quickly through the phases, which has helped us. I mean, when I started on this caseload in 2005, I swear we had clients who stayed on phase 1, SIP 1 is what we call it, of SOISP almost their entire time on probation, which I think about that circumstance right now and it's like, oh my gosh, that's so not what we should be doing. So we do, I feel like the team, we do a good job in terms of moving clients when it's appropriate. And it also has to have the agreement of the therapist to move SOISP phases as well. I also forgot to say at the beginning, I'm sorry, if anybody has questions, I think probably the best way to handle that is to type it into the chat box. And I certainly don't think you need to wait to the end if something comes up to ask questions. So sorry, I forgot that piece. Community corrections standards and level movements. Probably you guys know community corrections has this thing called the matrix, and that's somewhat R&R. You know, I haven't done a deep dive into all that, but it is kind of, it's another layer of things that clients and community corrections have to deal with and work with. Frankly, from my perspective, it can be a little frustrating because they add another level, not just the matrix stuff. Sex offenders and community corrections have additional things they need to be able to do to move in the COMCORE phases. So that's just kind of another piece in our system that doesn't 100% jive necessarily with risk needs and responsivity. And then Gary's going to talk about the other things. Oh, I guess I'm going to talk about the child contact based on constitutional rights. As you guys know, that sometimes that may not be necessarily what is in line with risk and needs. Sometimes it is, sometimes it's not, but it's now with the Burns decision, more of a constitutional right, obviously. And we have to have I've found, at least in my experience with the Boulder courts, you have to have a really, really good reason to be recommending that a person doesn't have contact with their own child. So it may or may not be in line with risk needs and responsivity.
Yeah, so now we're going to switch over and talk a little bit about the SOMB, how that impacts in a non-R&R situation. We tried, when we were rewriting the standards, we tried to infuse the concept of risk within the standards, but there are some places where it's unfortunately still a one-size-fits-all, and that's the sibling contact and then the 5.7 approved supervisor. So although a person who's committed a sex offense can have contact with their own child based upon the Burns case, it doesn't extend to other children in their lives, such as perhaps cousins, nieces and nephews, and in some cases, siblings. So as a treatment provider, what we have to do is do a risk assessment. It doesn't matter what the judge says or what the probation says. As a treatment provider, we have to abide by the standards. And so we do our own risk assessment. And if we believe that this person represents a risk to these children, these non-victim children, then we're going to act on that, and we will not allow contact. So that's one piece of this. The other one, the other part that is difficult is that 5.7 applies to everybody that's on probation. So even if you have a low risk offender who represents virtually zero risk to children, they still have to follow all the same 5.7 approved supervisor conditions that a person that is a high risk offender. And that's unfortunate. Maybe that might change sometime in the next revisions of the standards, but that's where we're at right now. So actually, with that, let's talk about some of those how we process those the standards revisions. This is really kind of old news. Started way back with an assessment, outside assessment of our standards in 2014, and so we've started working in about 2016, 17, and 18 and rewriting the standards, and there were all these incremental improvements or approvals that made by the board. They still make some incremental changes to them, and so the changes, they're all done in committees, and so it's a slow process. Denise and I worked on several of those subcommittees together, and to make these changes. And if any of you have been working in a government process, you know how frustrating that can be. May not be the best, but it's all the stakeholders eventually got all of their heads nodding, yes, we're going to go with this. And there's the link right there. You can always go to the SOMB website and download the most recent standard.
Yeah, actually, this is the only place you can get the most recent copy. Back in the day, they used to print out. I have like maybe 2 or 3 or 4 old, hard copy versions of the standards, and they haven't done that in a while.
No,
so there's no hard copy versions out there. If you want to look up the most up-to-date standards, you've got to go to that link. Okay, so now we're going to get into the actual changes that were made during this revision process. I've already mentioned most of these. We started with the guiding principles in terms of our revisions committee, and there was some important things removed, such as the no cure, which I am very happy that they took that out, frankly. Community safety is still deemed to be the number one priority. There's in terms of the no cure philosophy, there's language, it was very specific language put in there to say, no, people can change, and not all sex offenders are high risk, which is absolutely the truth. Again, we've said there's been a focus during those revision committee meetings. You couldn't go to one of those meetings without many people talking about, does this fit R&R? Is this R&R related? So definitely lots of risk, needs, and responsivity was injected into the standards. And then also an emphasis on the continuity of care, which is trying to avoid the situation when someone has done any treatment in the Department of Corrections. It's very difficult and has been very difficult to get any of those treatment records. So guys getting out of prison, even if they did phase 1, phase 2 of SOTMP, essentially they'd be starting over from scratch when they got out. And there's been a real movement to try and eliminate that and improve that situation.
So the evaluation section really is unchanged. We do now, as an evaluator, we have to write some verbiage at the end in the recommendation sections to respond to the special additional conditions of supervision, and we're supposed to provide the court a little extra language on the risk that this particular person presents to their own children. But outside of that, it's pretty much stayed the same. I want to note that we did add some language to make it, let's say, to answer some ethical questions that arose with pre-plea evaluations. I know many evaluators. I do quite a few pre-plea evaluations for attorneys and stuff. So those are, I know, really handy. I will point out that I've had some attorneys ask me about doing to actually be providing consult to their case. That saves some money because I don't have to write a report that's court ready. So I essentially do a risk assessment. I look at various things and give advice to you as the attorney as to perhaps weak spots in the case. And also it shifts an evaluator. As an evaluator, if you ask me to do an evaluator pre-plea evaluation, I'm neutral. I'm going to write the report as if I was doing it, for the court, which I am. If I act as an expert for you as a consultant, then I'm probably going to tell you things that I wouldn't necessarily put in a report. So that's just something to consider to save your clients some money, and it might actually be better for you than having a full OSE done. Yeah. So and then section 3, Denise, let's go ahead.
Wait, Gary, before we go on, I wanted to say one thing about evaluations.
Okay, sure.
And that's just that I think hopefully all the defense attorneys in here know, I know Katrina knows, but we went through a pretty rigorous RFQ, request for qualifications process with Boulder Probation with the help of state folks at the school in Denver. And we have a very specific list of approved evaluators who went through that RFQ process. So you guys know the name Mary Miyasaki. She's the PSI writer here in Boulder for the vast majority of sex offender cases. And so if there's an eval, a pre-plea or otherwise from an evaluator that's not on our RFQ list, then we will not be accepting that evaluation. So I think most people, I hope everybody knows that. We haven't had to reject many recently, but just an FYI on that. And I can get the list. It's about 5 or 6 evaluators on that list. We just recently added Erica Klingberg to that list. So anyway, that just a FYI on that.
All right. The treatment section, again, this is probably information that you don't necessarily care about too much about how the treatment standards have changed. I just want to say that the standards were simplified. We went from having 22 requirements to having 6. And we're closer to being evidence-based, not 100% there yet. The thing that I take note of is that we changed the language in the treatment section. The people that we work with are called clients versus offenders. So, Denise, let's see, the next slide is, what happens in treatment? And this is the big black box that, there's no secrets here what we do. I just want to point out a couple of things. There is no standard training classes for how to be a treatment provider. You have to meet the SOMB standards. So people come to treatment, and treatment providers come in many different ways. And so even though we all follow the standards give us a lot of leeway into what we actually do. So don't necessarily expect, just because a person goes to treatment provider A, that they're going to get the same treatment they would do as if they went to B. Don't expect uniformity between us. If a person is discharged from one provider and is transferred to another, it becomes a little more cumbersome in trying to figure out what did that person actually complete within your own treatment provider, within your own treatment agency. Like I use a 6-page assessment forms to try to ascertain just what did the guy learn from the other provider when they come over. That being said, I just want to let you know that we're not all the same. Well, and I'll say that for probation. Probation jurisdictions across the state are not the same either.
That's very true. But wait, Gary, let me just chime in here real quick. That actually it's that I don't know if that sounds frustrating to you guys, but it's really very a good thing, because that helps the probation officers be able to do what we call treatment matching for our clients a lot better. And we have a list in Boulder Probation. It's top secret, of course. I can't share it with you, but we have all these little notes that all the POs on my team have about each and every treatment provider. And we have clients who might, maybe we think they're going to do better with someone who has a mental health expertise or background. And we have a provider, an SOMB provider, that we use her a lot because she has amazing skills just as a mental health counselor and on top of the SOMB approval. And then we have somebody who likes to just work individually with clients, and we get clients, and that's part of R&R is the responsivity piece, that there are some clients who probably shouldn't be in group and would do better doing their offense-specific treatment individually. So we've got a couple providers that we utilize in those kind of circumstances. It might be a little frustrating, but I hope it's not, because it's really a cool thing for us to be able to work better with clients and hopefully set them up for success with selecting which treatment providers to refer them to. So great.
Yeah, I'd like to see that list sometime, Denise. So let's see. So just a few things. It used to be the intakes, our intake, and it was very highly prescribed by the SOMB, and we pretty much mirrored what the terms and conditions were, but that got changed. So our intake contracts are very much risk and risk factor oriented. Now about treatment. I wrote down here that treatment is anywhere between 2 to 4 to 10 years long, which is kind of amazing. I think the shortest time period I've had for a client was about 20 months. A low risk person who did everything we asked them to do, and they were finished pretty quickly. And a typical time frame is about 4 years. I've received clients from other agencies that have been in treatment for 10 years or longer, which is kind of amazing to see that. So I just want to point out that it's a long-term process. It's expensive. Every year the SOMB puts out data about what treatment costs are across the state. And actually, since I've written this, it's gone up to almost $450 a month. So treatment is expensive. It is not a feel-good experience. People come to us for treatment and they've done something that they really don't want to talk about. And I understand that. People usually have a lot of shame around what they've done, and they would rather just be left alone, I think, in a lot of cases. And yet our job as providers is to help a person to take full responsibility for what they've done, and also to look inside and ask themselves, how did I get to this point? I can talk about it. It's a little bit like if you've got something in your eye, you got a little speck of dirt or something in your eye, and it hurts. It hurts every day. Every blink of your eye, it hurts. And our clients, it hurts them to know what they've done. But you can play with it. You can blink your eyes. You can do all kinds of stuff with it, and it's still there in your eye. And sometimes someone else needs to help you go in there and pull that thing out. And sometimes it might hurt doing that. But I can tell you that the guys that are successful in treatment with us, they do eventually feel better. They gain their self-respect. They gain their integrity. It's quite a dramatic process, but it's not the kind of treatment that necessarily feels good all the time. The other piece I want to point here, Denise already talked about this, not all clients are high risk to reoffend. It used to be, maybe 10 years ago when I started this, that everybody assumed that these clients are just ready to go out and reoffend at the moment's notice. If they had an opportunity, they would do it. But we know that's not true anymore. And so that I think that most treatment providers these days, I think, agree with that. And then successful discharge, yay! The big piece here is that it used to, the old standards, you actually could not discharge a person from treatment until they finished probation. Well, how crazy is that? Now we can discharge clients more easily. It's just a therapeutic decision to discharge them. They may have years and years left on their probation to complete, and that's actually caused a little bit of a problem with probation, because now the CST no longer exists with the treatment provider because we've discharged the client. I don't know, Denise, did you want to comment about that?
Yeah, well, it does, we get used to actually going, because the next slide talks about the teams model, right? We're so used to the CSTs operating and the POs operating as a team and never making decisions on an island, and having the therapist and sometimes the polygrapher and others to kind of bounce ideas off and decision make. So it's a little unnerving, like, oh no, like they're out of treatment. But like, for instance, I've got about 9 or 10 guys right now who, have like 20-year sentences. I think some of them are flat, some are determinate, some of them are indeterminate, and they've been out of treatment, all of them, for years and years and years. But so I feel kind of comfortable doing it. But I should be knocking on wood when I say this, but there's not a lot of decisions to make with those guys. Like they're pretty much living their lives, and I have minimal interference with them. But if there is a decision to make, it would be the probation officer making it alone because they're out of treatment. So
yeah. Oh, Denise, before we move on, I have a note here I wanted to say to the attorneys. So when going back to treatment piece, when you're talking, this is the conversation I'll have on intake with some clients, and I'll be going over some of this stuff, especially the part about how expensive it is or how long it is. And not often, but sometimes I'll have a client that will say, what, it's years long? My attorney said this was like a substance abuse treatment. I'll be done in 6 months, or the cost. They weren't ready for the cost of it. And it'll say, well, I thought the state is paying for this. Do I have to pay for this? The vast majority of my clients are all self-pay. Now, probation might pay a little bit of that, but it comes at a tough time because a lot of these guys lose their regular paying job and they have to go to something else that doesn't pay as much. So I just want to make sure that as you're sending clients off, that if you're unsure about what to tell them about what to expect for treatment, please don't tell them that it's free and they're going to be done in 6 months. That's just not the case. So
yeah. Okay, so then moving on to the changes in section 5.0, and there were a lot of them, and probably, again, the big philosophical one was moving away from the containment model, and now we have the teams model: treatment, engagement, assessment, management, and supervision. I guess one of the real big themes of this section in regards to the teams piece is there has been some fairly famous, and at least in me and Gary's world, conflicts that have arisen between treatment and probation. Of course, that doesn't happen in Boulder, right, Gary? But and I mean, I'm not lying. I can't. We're very collaborative. Anyway, in the past, there's just been some pretty big conflicts with treatment and probation, and staying in your lane, and that's led to some problems. So these standard revisions really try to define the role of treatment provider and define the role of supervising person, and emphasize and encourage each of those sides to stay in their lane more. So that was, like I said, that was probably the biggest kind of changes that went into 5.0. And I always put this note in here because it's always probation, or 99.9% of the time. There are still conflicts. We have dual supervision cases with parole, probation, when somebody's on both. And we also have guys that are serving community correction sentences that are on probation. So in the standards, it does state that the supervising agency that has the client for the longest duration, and that's almost always probation, they should be the lead agency. And so if there is disagreement, like if probation and a parole officer don't agree on a specific decision or how to handle a client, technically speaking, since parole is only going to be 3, 4, or 5 years, whereas we're talking probably indeterminate or at least 10 or 20 years for the on probation, that it's the probation officer that should have the final say. That can get a little dicey, admittedly, but we try and work around any disagreements that we have, and we typically have pretty good relationships with the parole officers in our jurisdiction, as well as the halfway house case managers. So I think, am I doing this? Contact with children, we've kind of discussed this. If someone hasn't been granted contact with their child via the Burns decision, then there's several different ways for a person to earn that kind of contact back with their children. This slide goes over them. I've already said if the court says nothing, then the default is because of the Burns decision, they get to have contact. Then there's the court can also order a child contact screening. Oh, and I wanted to say this to the attorneys out there. It is so helpful. It is so helpful to probation, but more importantly, it's so helpful to your clients. If someone is going to need a child contact screen, that to get that done pre-sentence. Now, again, I'm not saying it's always going to benefit your client, because the child contact screen might not come out in saying that or recommending that there is contact, but it's really advantageous to get it at the same time that you're getting the psychosexual evaluation, because it's cheaper. Because like Dr. Brake has always told me, like there's so much like personality, there's studies and exams and stuff that goes into all these evaluations. So if he doesn't have to repeat those same Gary, I'm blanking on the word, but the testing that's done for the psychosexual evaluation, many of those same tests are used in the child contact screen. But if we ask for the child contact screen a year after the or the psychosexual, or 18 months after the psychosexual, then we have to pay a lot more money because they have to redo the testing. So anyway, hopefully that makes sense. If it doesn't, type something into the chat, but it's really advantageous to get that child contact screening done along with the psychosexual evaluation. And Gary, you do both, so I'm not crazy, right?
No, I've done both. The difficulty comes is in the child contact screening. There's a polygraph involved, and whether you like or dislike polygraphs, there is some benefit in having completed a few polygraphs, like a maintenance polygraph, before you go in for the child contact screening polygraph. So if your client wants to do this, I suggest that you connect with a treatment provider to help them prep for that polygraph. And there's also some questions in the CCS that talk about treatment. And so if they're already involved with a treatment provider before they get sentenced, then that person can answer those questions for the CCS, as well as prepare the client for doing that polygraph.
Yeah, so just again, returning to the slide where we're talking about the ways a person can be allowed contact with their own child. They can just be allowed it at sentencing because there's no evidence to suggest they shouldn't be allowed contact. There's child contact allowed because the child contact screening was done and it recommends it. Then there's people who have to meet the full 5.735 criteria, which is a big list of stuff. And then there's clarification with the victim if that is completed once, which actually takes a while to do. There's a lot that goes into having one of those clarifications happen, and it really needs to happen after a person has been sentenced to probation. once a full CST has been formed. And then there's the young adult modification protocol as well. Like we mentioned earlier, that it applies to clients who are put on probation between the ages of 18 and 25. And YAMP actually allows us, the CST, to have quite a bit of flexibility with a variety of the terms and conditions and standards and guidelines, really. So that's kind of up to the CST to make those modifications if someone meets the criteria. And it's not just the age. There's a few exclusionary pieces to YAMP. So I'm glad I remembered to say this. Not every 18 to 25-year-old is going to be eligible for YAMP. And there's a big criteria checklist that's in the standards and guidelines. It's one of the appendixes. If you are interested, if you have a client that's age 18 to 25 and you're curious if they would meet YAMP, you can look at that appendix, and there's a checklist that you can go through, and you know.
Yeah. Well, and I want to give a word of advice to the attorneys. There's a lot of nuance to all of this contact with children. And there can be conflict. This goes back to the slide that we had about conflict between the standards and whatnot. But we've got this case happening right now, which highlights my point about being careful about what you say to clients about having contact with children. We just recently got this case from Boulder County, 34-year-old man, non-contact offense, misdemeanor. And the judge was silent on having contact with his own children. And so the terms and conditions also applies towards having contact with your own siblings. So as it turns out, this particular guy, even though he's in his 30s, he has a 12-year-old sister. And even though probation and the judge says he can have contact with his 12-year-old sister, the SOMB standards says no, he can't. Now, the sad thing about this is that I don't think he presents a risk towards his sister, not at all. But again, it's another one of these non-R&R situations where what I did was I asked him, please don't have contact with her. And as it turns out, there's enough age difference. It's not a big deal to him because he doesn't live with her, doesn't see her very often and whatnot. But we could have bumped up against a rock and a hard spot here with this particular case because he's going to have to meet the full 5.7 approved supervisor conditions so he can have contact with his sister. Anyway, I just want to bring that up. So pick your words carefully when you're talking to your clients, because it really comes down to treatment. And what happens with treatment, all we can do is say, if you're going to have contact with that person, then we're not going to provide treatment for you.
And
anyway, go ahead.
Also, just to piggyback, not really piggyback, but the other thing about contact with children, and we can talk about how a person is able to have contact with their own children or siblings, in certain situations for sure. But if we're talking about their son or daughter's best friend or their cousin or their, any other minors, we don't have the authority necessarily, certainly early on, anytime early on, to grant that a client can have contact with other children. It's not allowed within our terms and conditions or the Sex Offender Management Board standards and guidelines. So sometimes clients, and that's a legal argument for one day down the road, but can a parent truly parent if they don't have any, they can't have sleepovers, they can't have this, they can't have that, they can't go to the school necessarily, if there's kids around. So there are limitations to what probation and treatment can allow in terms of contact with children.
All right, so here's the CCS. Denise and I talked briefly about that in the previous slide. Those of you who've been in this business for a while, you probably remember this as being a child contact assessment. We changed the terminology because it's really not much. We really were never doing full assessments. We don't have any assessment instruments that can really tell us how much of a risk a person is to their own children. So we changed the terminology to a screening. We also simplified things so that it would be less expensive because the state will not pay for this. This is a self-pay thing that a client has to pay for. The part that I want to point out here is that,
that's not necessarily true. We might pay for it, but we would probably do what we call recover the costs.
Oh yeah, well,
so we're paying for it because if they can't come up with the money, we're doing that right now with the client. And actually, I think we're only asking that the client pay us back $400 as opposed to $600. So okay, just a little clarification.
Right. Good for you, Denise. Yeah, it's the shell game. Pay me now, pay me later. Yeah. The thing I want to point out about the CCS is that the outcome of this process is one in which the CCS writer makes certain recommendations. So, for instance, they may recommend that this person represents virtually no risk or very, very low risk to the child. And so in the end, it's the CST that has to agree to allowing contact. Okay, so that's the first piece. So it's possible that a person could get a positive CCS, but then still not be allowed contact immediately. So that's one piece. The other thing that can happen is that the primary caregiver of this child also has a say in this process, and that person may ultimately refuse contact. Okay, but now that's not a criminal court piece. That's a family court piece, and so because I've had clients before that says, well, I've been allowed contact by my CST, but I'm still not seeing my child because my ex-wife is not letting me see that. Well, again, that puts it into the family court area. And I just want to say, another hat that I wear is I'm a child and family investigator. I'm a CFI, those of you who work in that field as well. And so it's kind of a specialty for me to be involved in those cases in which we have approval from the CST, but then we have other people who are denying contact and how we move forward with that. So it's important that the client understand that this is just one hurdle of perhaps several hurdles that they have to get over so they can eventually see their children.
And just to clarify, I mean, hopefully this is clear, but it isn't always to everyone because we've had people who want to do a CCS so they can have contact with other children, like children that aren't there. The CCS is only for assessing. It's only a screen, not assessing. It's only a screen for your own child or parental role, a child over whom you've had a parental role. Not cousins, not siblings, not friends of your daughter. It's only in regards to your own children. Ooh, everybody's favorite topic. So I do want to say I think with the standards revisions, there's certainly made it, I think, pretty clear, appropriately so, that the CST should not be basing all of their decisions on the results of polygraph testing. In fact, but just using polygraph results alone, we're not imposing sanctions. We're not imposing incentives or sanctions for that matter, if only based on somebody passing or failing polygraph tests. And now if someone's failing maintenance polygraphs, we may not be signing off on a ton of new safety plans, for example, or allowing them to do some increased pro-social activities because we have some concerns about the maintenance polygraphs, but we're not taking anything away. So hopefully that makes sense. We're not imposing sanctions. Now, if someone fails a polygraph and has all these disclosures about violations, that's a different ballgame. There's legitimate things that we can be addressing and sanctioning or incentivizing based on that. But if someone just has nothing to say and goes in and fails a polygraph, we try to work with those clients in terms of why they might be failing, but we're not imposing further restrictions. So I think that's important. I don't know, do you want to talk about the rest, Gary? I don't want to talk about polygraphs.
Well, there's so much here. I think the movement in the polygraph area has been an improvement. I can remember just 10 years ago, if a person got a inconclusive on a polygraph, we would put them in a failed polygraph group, and all kinds of sanctions would be happening to them. Whereas in today's world, I've even had CSTs look at a polygraph that had a series of inconclusive results and then cleared them up. I mean, by talking to the person and getting some information about what went on, and then we just move forward, not even having to retake that polygraph. Sometimes, that usually in the past, people would have to retake polygraphs until they got pass. But now, as soon as we can get what we think is a reasonable explanation for the results, we move on. We've also extended, it's possible to extend polygraphs. It used to be we would have them done every 6 months. Now we can extend them to once a year. So things are loosening up quite a bit with regard to the timeframes. One of the areas that we still, that's really difficult, though, I think, is the last bullet there, the instant offense polygraphs. For instance, if a person comes in saying, I didn't do this, so they're in some level of denial. So one of the standard things we do is they say, okay, fine, we'll have you go in and take a polygraph around those questions, around the particulars of your offense. And that data really helps inform the CST as to what direction to go with his client. The majority of the time, what eventually happens is that the client ends up admitting, saying, well, yes, I did have some contact here or there. So the polygraph is a really beneficial tool to helping us get to the behaviors that we can actually work with.
Yeah, but I got to say some more here. So we're I'm in a quagmire with a case right now. I'm not going to go into all that detail, but I guess I would say our role is not to retry the case. Someone has either pled guilty, taken a plea deal, and to a sexual offense. That's why they're on, sex offender terms and conditions, and that's why they're on my team for supervision. Or they've been found guilty by a jury. So how I train my POs, our role is not to change. I mean, that's not our role in terms of the legal system. Now, if somebody in the rare, extremely rare, I would say extremely rare circumstance, someone passes an instant offense polygraph, we work within a realm of they're not taken out of sex offender treatment. We don't motion the court to remove sex offender terms and conditions. That is crazy talk. We do not do that. We can have a CST staffing and try and figure out, okay, what's the best way to treat this client? How can we move forward? Can we modify treatment? Can we adjust treatment goals? Stuff like that. They are going to still be taking sex history polygraphs. They're going to be taking maintenance polygraphs. That stuff does not change. And it's, I hope you attorneys out there don't want to put probation in certain positions where we shouldn't be, frankly. So anyway, I guess I just want to say that, and I also think, we have actually a new one of these new adjustments to the standards and conditions has been if by some chance someone does pass an instant offense polygraph, it's now mandatory that the polygraphers do something called a quality control, which means, let's say they pass a polygraph with polygrapher A, they pass an instant offense polygraph with polygrapher A, then that polygrapher A has to send their charts and their report, their charts, all that stuff to 2 other separate polygraphers who review those charts and have to agree with those results. So it's kind of a process there. And I would also say the more common, the other reason we do, which I like much better, instant offense polygraphs, is when the person's not in total denial. They're just saying there's what we call a significant discrepancy in what the client is saying and what the victim reported. Kind of the easiest, kind of most clear example of this is, let's say the victim says there was penile penetration or even digital penetration, whereas the client is saying, oh, no penetration happened. I just touched over the clothes or under the clothes, but not even close to penetration. In my opinion, that's a significant discrepancy, and we'd be testing and we'd be doing an instant offense polygraph on that discrepancy. So anyway, I don't like instant offense polygraphs right now, but that's what we're doing in terms of what the SOMB has said most currently about those tests. Victim-centered. Really brief on this, although this is a section very near and dear to my heart because our probation victim advocate, Danielle Fagan, and I just did a presentation actually to the COVA conference. And because I think in Boulder, we're doing some really cool, very unique, that no one else in the state is doing, activities to try and be more victim-centered, because it's really hard to do, I would say, in probation. In probation, you get really offender-focused. So trying to do just small things, but actually they've been pretty meaningful. And I'm more than willing to talk about that later. That's not for today, but we are required to, in the SOMB standards, to be victim-centered, to find ways to be victim-centered. So, and one of the things in the standards is that Gary's agency, any offense-specific treatment agency, has to have, usually it's as a consultant. It's not like they're always there, but as needed, a victim representative to help with their agency when there's victim issues or questions or concerns that come up. Okay.
Oh yeah, so this one we've Denise, we've kind of talked about this one kind of around as we've done. Yeah, the bullet there, SO conviction with SO treatment ordered, but not SO terms and conditions. I don't think I've run up against this with anybody from Boulder, but in another county, another district, we've run against this where we've had a client that has been ordered to do sex offense treatment, but they're not on SOISP, or they don't even have a SO probation officer. So we're starting to get a lot of different types of cases coming through, and so we figure out how to do it. So in some cases we have to go back to the SOMB and ask for a variance, because people need, for instance, we'll get people that'll be ordered to do boundary classes, to work on boundaries. And so what I want to say here about treatment is that kind of goes back to the denial piece, or the what do we do with a modified treatment plan, is that in sex offense treatment, about maybe a fourth of the topics that we go over in treatment are actually offense related. The remainder, the 3/4 of treatment, is actually non-offense related. It has to do with a person's self-regulation, their emotions, their thinking. their stability in life. There's a lot of things that people can benefit from SO treatment that's not SO related, and so that's what we're finding that fits in with some of these issues with court orders.
Well, and I would say, at least in Boulder, if we this would happen mostly. I've had some conversations with Christine Rinke here in Boulder. I think some of the sentences that seem a little wonky or like what is happening come from county court, and for a variety of reasons. So if someone was ordered to do sex offender treatment, we would be filing a motion immediately if they weren't ordered. If the sex offender terms and conditions weren't ordered, we would be filing a motion to get those put into place, because it's exceedingly difficult to have someone in SO treatment that's not following the SO terms and conditions. It creates havoc, really, and lots of problems, not just for supervision, but for treatment as well. So we haven't seen that too much, but there's always a couple a year that come through somehow just oddly and weirdly, and we have to fix. So after all that, after we just talked to you about all, this is so silly, but it's true. After all of those revisions and years that it took, and going to those excruciating damn revision meetings, we are now the SOMB is under another mandate to revise them again. And that process has just started, I think sometime in late October. So I am not going to those meetings. I can tell you I am done going to those meetings. I can't bear it again. I did my time with that. So I guess it's just stay tuned. We'll see what new changes come up from this next revision process.
Yeah. Hey, Denise, I wanted to tell you, while we were sitting here, I got an email from the SOMB inviting me to attend one of these meetings.
Well, good luck with that, my friend. You'll be on your own. Okay. So now we're going to talk about, we talked about the changes to the standards and guidelines. We're transitioning to the changes in the sex offender terms and conditions. And I just put together this little background in regards to SOISP that goes way back to statute in 1998. It took a while for the probation departments to start figuring out what the hell does this mean? What is SOISP? What is that program going to look like? And for a long time, well over a decade, there was no substantive changes to those sex offender terms and conditions. Until, of course, Burns started creating a whole bunch of chaos, right? And in January of 2017, that's when we had the big changes to the terms and conditions regarding the contact with your own child. Then we had even bigger changes, and those came into effect in November of 2018. And that's what we're going to talk about now. So what are the changes? So I can send these out. I mean, hopefully everybody is familiar with them now, but if people want me to send out the PowerPoint, I can do that. And I can also send out some of these documents like the newest terms and conditions that we're operating under. And so when you're looking at them, number one, it only applies, the new term and condition number one only applies to people who are placed on SOISP. So if it's non-SOISP misdemeanor, we just cross that out. But then 2 through 22 still apply to everybody. They apply to everybody. They're going to, there's no ifs, ands, or buts. 2 through 22 apply to anyone who's placed on SOISP or non-SOISP. Number 19. Now, number 19 mandates that a client has to sign the computer use agreement, and it allows probation to monitor any and all electronic devices. So again, that's for anyone who's on sex offender probation. Probation is allowed to monitor electronic devices, and they have to sign the computer use agreement, which is also newly revised. So I can send that out as well. Then we have special additional conditions 23 through 29. Now, these are conditions that the court has an option as to whether or not to impose. And I think we do a pretty good job in Boulder, but if a court wants to impose or put any of those 23 through 29 restrictions in place, it has to be said out loud in court at sentencing. Kind of like the Burns thing, like they have to make a vocal articulation on the record about what they want to impose. So, and you'll see. Hopefully some of you guys know this. So, to help us do a really good job in navigating these, especially these optional terms and conditions, 23 through 29, Greg Brown was the chief back then, and and we still utilize Jim Tanner quite a bit in this department. And Jim helped us. He did a big training. Maybe, I don't know if any of you guys were at that training, but it was mostly for a lot of POs. There were some attorneys there, though. I think actually maybe Nicole Collins was there. Anyway, so Jim did a huge research study, and he really helped us fine tune when we should be recommending in the pre-sentence reports to restrict, when we should be restricting, when we have a foundation, when we have a nexus, I think he called it in Jim Tanner's report, which is available. I think it might even be on the SOMB webpage, Jim Tanner's research report, because the SOMB incorporated it as well. Like, it was awesome. And it's so cool because it came from Boulder.
So Denise, it's definitely on Jim Tanner's website.
Yeah, it's on. Yeah, so it's for sure on Jim Tanner's website. So anyway, Jim helped us navigate this process in terms of when we have enough evidence in the pre-sentence report, the psychosexual evaluation, and when we have a cause to ask that the court restrict one of these 23 through 29. And I'm going to go a little bit more into depth with these. So when it comes to 23, 24, and 25, it's or. There's an actual or written in on the terms and conditions. So we only want one of those. If we're going to request one of them, it's only one of them. It's not 23, 24, and 25. It's just one of them. I can tell you that probation, if we're going to be recommending one of them, it's almost always 23, on occasion 24. And really what 23 says is that it's up to the CST to determine what should be restricted in terms of internet access. 24 allows the client to access the internet for work and or school purposes only, unless approved by the PO. They could expand it. 25, I don't like 25 because we would have to go back to court. It says restricts all internet unless ordered by the court. So I'm just trying to save us some work in terms of we would have to file a motion. If 25 is restricted, then we'd have to file a motion. And, that's just work for the POs that I don't think is necessary, because hopefully the CST is really working with the client and they would be able to gauge what should be allowed and what shouldn't be. So then we have 26 and 27, which used to be combined into one big one, all about not accessing or possessing sexual material or going anywhere where that kind of material is you can access it. So they just split it into two. We've been doing this for over a year now, so I can't think of one situation where we feel we have a legitimate cause to ask the court to restrict one of them where we haven't asked for both. So usually if we're going to ask for either one, 26 or 27, they to me, they go hand in hand. So we ask for both to be restricted. And then there's 28 and 29. 28 is about the use or possession of cameras, recording devices, and 29 is about social networking. And I can say that these are the two that we recommend the least, because if there has to be evidence to suggest. Now, of course, if a guy was caught, putting we've got a lot of these cases recently where people are putting cameras into places and getting recordings of inappropriate stuff. That's a no-brainer, right? Of course, we're going to ask the court to restrict number 28. But if they didn't use a camera, if there's no evidence of any issue with cameras or recording devices, then we're not going to ask that be restricted. And the same with 29, social media. A lot of the online offenders, they utilized. They were chatting with somebody who was under the age, or sending pictures, or using all these different websites and social media kind of stuff. Those are easy. Those are the ones we are going to ask. But if there's not anything in the psychosexual evaluation or during the pre-sentence interview that seems concerning regarding those two, then we don't have the ability to ask that the court restrict them. So that's, obviously those are huge differences. And I think, again, that's the whole point of trying to get away from the cookie cutter approach and trying to be more individualizing in terms of somebody's supervision. Okay, the Allman decision. I mean, I don't know why I'm talking about this. You guys are the attorneys, but the Allman decision is, gosh, I don't know if you guys know, but the whole Allman decision came out of Boulder. It wasn't on a sex offender case. It was economic crimes case. And not legal. I can't talk the legal mumbo jumbo, but essentially what it's saying is that we had a lot of these split sentence decisions where somebody's pleading guilty to multiple counts, and on one count they go to Department of Corrections, and on the other count they get a consecutive probation sentence. I actually thought that was a nice way to nice thing, but the Supreme Court didn't agree, and now those cases are not legal. I know those sentences aren't legal, and I can't say what's happening necessarily across the state, but I do hear not just in Boulder, but so sometimes we've had where the court is vacating all of the guilty pleas or withdrawing their pleas, whatever the correct terminology is, and they're just being resentenced to probation. Katrina and I have had a couple of those cases recently. So that's what I have heard is going on around the state as well. So that's what's happening with the Allman decision. And so probation, we still have many Allman cases that we're still supervising, obviously, and that haven't gone back to court. And probation, we are not advising clients of this. I don't feel it's our role to do so. Now, if a client comes in and stuff like that goes amongst clients pretty quickly. So if a client comes in and asks their probation officer about this, we don't give them legal advice, but we just say, well, yeah, you probably should talk to your attorney about that. So we just send them to their attorney. We don't give legal advice, and we don't bring it up unless they bring it up.
Well, and Denise, before you move on, I want to say something to the attorneys. There's a benefit to the clients staying on, if they come through on dual probation and parole, there's a benefit to them to staying on staying on parole, because parole pays for their treatment. Mm. And so I know that they have another layer of oversight. They have a parole officer and a probation officer, but the probation officer takes the lead. So, and in the cases where we've kind of bumped it, when I've watched probation and parole bump heads against each other, probation almost always wins out with that thing. So if you happen to get a client coming to you talking about this, advise them that, well, if you end up getting a pure probation resentencing, then you're going to be in a self-pay mode. So that's just something to consider.
Yes, and then we have the kind of the more recent follow-up, I don't know, somewhat related to Allman, is this People versus Ellebrocht. But as Katrina told me too, I had to clarify that it's not law yet. I guess it's still pending appeal with the Colorado Supreme Court. But as what we've been advised, that's about is that all men may not be that split sentence may not be an illegal sentence if the probation part of it is an indeterminate sentence. So again, that's for you attorneys to fight about in court, but they're pretty big deals because I know in Boulder we utilized. I think we have a lot of, maybe more than, I think Larimer does a lot too, but Boulder may be up there in terms of how often or how frequently we were using those split sentences. So oh yeah, appeal cases. You can go on this one, Gary.
Well, yeah. This is an area in which Denise and I differ. So going back many years ago, we started seeing clients on appeal, and then it kind of all went away. And then the problem comes is, well, what do you do with a person on appeal? They're not necessarily. We used to treat them like they were a denier, but they're not denying. They're just appealing their case. And so there were very few providers that would see clients on appeal because you also had to file for a variance. And a lot of treatment providers just don't want to go through the hassle of doing the variance. But over the years, every variance that was applied for to the standards, well, let me back up. The reason why you have to have a variance to the standards is because one of the very first things that you have to do in treatment is to assess a person's responsibility, taking responsible for their offense. Well, if you can't talk about the offense, how are you going to do that? So you can't really do treatment without talking about the offense. Remember that I talked about only about 25% of treatment is around the offending behavior, but if you can't talk about it, you can't do treatment. So if you were going to work with folks in appeal, then you had to file for a variance. Well, every variance that was applied for with the SOMB was approved. So this came forward to the Best Practices Committee, and we looked at that and we said, well, we should make a change to the standards to allow this process to go forward without having to file an appeal. And so that occurred just, I think, last year when the section in the standards were changed. So now any treatment provider can do treatment for a person on appeal under some conditions. And then, but you just can't, you do everything but talking about the offense. Now, right now, FETS, the agency that I own, we have 3 people that are in appeal. We see them individually, and we do the full sex offense treatment, except the sections of our treatment program where we talk about the offending behavior, which means that we do about 3/4 of our treatment. If they were to happen to finish treatment, that finish all of our curriculum, we cannot give them a discharge because they actually didn't do sex offense treatment. They didn't, if you look at the things that a person has to do to get a discharge, they can't do that because they're on appeal. Now, the reason why Denise and I are at difference with this thing is it makes sense to me for a person who's on appeal to go ahead and go into a sex offense treatment program, because one of 2 things is going to happen with their appeal. If they win their appeal, then they're done. They will have benefited from working on all these areas in their life, working on their self-regulation, working on a lot of places, a lot of treatment topics. If they lose their appeal and then they are ordered into sex offense treatment, they've already gained the benefit of being in treatment for months or years and doing all of the other stuff. And so now they're ahead of the game. So anyway, if Denise wants to talk to that, she can. But let me just say, if you happen to get an appeal case, it is somewhat complicated. Not all treatment providers want to work with folks under appeal. So you'll have to kind of call around and find out who will actually see the clients. What do you want to? What's point and counterpoint, Denise?
Yes. Well, okay. So, so I will say that I actually had two clients, and it's been a while that I supervised. I think one of them actually may have been with Jennifer, but who were they started probation, and they were on probation SOISP with me, and the district attorney granted them immunity use agreements. And so that worked out great. I had no problem putting those two guys into full-fledged sex offender treatment because under that immunity use agreement, they're supposed to be, and they have to be, talking about their offense. So they are able to 100% fully participate in offense-specific treatment. And both of them lost their appeal, and that's fine. And they ended up, they're both still on probation with us. And doing just fine. So unless a person is given an immunity use agreement by the district attorney's office here, with Boulder probation clients who are appealing, we are not putting them into any appeal groups or appeal individuals like Gary was just talking about. I just strongly disagree with someone who is not taking responsibility for their offense and we don't force it. They are exercising the constitutional right to appeal their case, but they don't have a constitutional right to be placed into sex offender treatment and make all this progress when I think it's such a key component to be taking responsibility and talking about what the heck you did. 9 times out of 10, our clients, we can put them in other kind of treatment while the appeal process is, these day and age, back in the day, you seem to get sex offender clients who didn't have any other problems. They just needed sex offender treatment, but that's the exception. Most of our clients have alcohol or drug problems or mental health, significant trauma, for God's sakes, trauma. We can treat the trauma. We can treat alcohol, drugs, mental health. And frankly, I feel like cognitive behavioral, just kind of a CBT group at Center for Change or BTS, that's not going to do anybody harm. It's not going to harm anybody to do a group like that. So in Boulder probation, we do not utilize this appeal group or appeal individual situation. And I'm sticking to that. So just so you know.
That's fine. And I guess I want to point out that not all appeals are the same. Denise, you and I have worked on a couple of guys that were admitting to their offense.
Yeah.
They were appealing the sentencing.
Yeah.
And
yeah.
That's a different animal.
Okay, we're getting close here, guys. And so we were asked, this is a new part. This is a new slide, the only new slide really. And that's to talk about kind of what's happened with sex offender supervision and treatment, given all the COVID stuff. I'll just start. It's been it's really it's been an adjustment for sure. I think it's been the worst for the sex offender team, really. I think other teams, we've always placed the highest emphasis on home visits, for example. I've got POs who love doing home visits, and it's really an integral part of sex offender supervision. And for many, many, many months, there were no home visits happening, as per our whole Boulder probation department. So we have slowly started doing some selective home visits here and there, although I can't say that that's going to continue if the cases, if the COVID spike continues in the direction it is right now. So that's been one big difference for the sex offender team, not doing those field visits. We're doing a heck of a lot more phone appointments, but really what we're doing, and which actually is kind of a good thing. I think I mentioned I have a bunch of guys, who have been on probation forever, and they're just waiting out, the last year or a couple years of their sentence. And it's been great having phone appointments with them. And frankly, if COVID, one day just disappeared, some miracle, I probably would continue just doing phone appointments with certain clients. And so would the rest of my team. So that's actually been kind of cool, but we would certainly be seeing more than we are now. But we are seeing new clients who are just sentenced. We're seeing them mostly in the office. If we've got a lot of problems or violations or just issues with a case, high risk or high needs going on with a client, we're usually bringing them in more often than not, maybe mixing in office appointments with some phone appointments. So yeah, it's been an adjustment for sure.
Yeah, same here for treatment. Part of the problem with teletherapy with this population is that most of the guys don't have access to the internet, or they have limited access, and so we can't do Zoom meetings, which would be nice. So we're doing phone conferencing and stuff. So what we did is we shifted, back in March, I guess it was, when we had the first spike, we shifted to all teletherapy, which initially it was just doing individuals, and then we started doing conference calls, and that actually worked out pretty good. What was interesting about it is that some clients responded so well to it, they actually started disclosing more information over the phone, and I think it had to do with maybe a sense that you're anonymous. That people can't see you. I don't know. It was interesting. So we actually got more information from some of our clients. But eventually what happened is that the clients were telling us that they actually missed the group. I mean, these are the guys get a lot of support from their peers in these groups. You know, we have small groups, as all treatment agencies do. We're limited to 8. 8 people in a room with one therapist. You can have 14 if you have 2 therapists, but most of our groups at FETS are on the order of 4 to 6 people. So, so eventually, really by somewhat request of the clients, we started in, what was it? August, I guess. I think it was in August. We started doing groups again. And but we had small groups of just max of 4 people in a group, and we've been doing that for the last several months, and that's been really helpful. I mean, getting back to the way we used to do business. But now, just this week, we're going back to teletherapy sessions, and a lot of the guys are grumbling about it. The therapists too are grumbling, but. But the protocols that we had in place while we were meeting in the small groups was every therapist had a thermometer, so a forehead thermometer, so you could take everybody's temperatures. Everybody had masks. We did have three times in which people we discovered after the fact that they had tested positively for COVID. So we told everybody about that. We shut the groups down. We went to teletherapy for 2 weeks, and then we came back again. And so, that one, I guess I can say that at least our agency, we were not a vector for the transmission of COVID. There are some agencies around that have not gone back to in person. They've maintained teletherapy throughout this whole time. So right now our plan is to do teletherapy with groups, but then meet individually, because we really think that, well, in particular with probation not having, when probation was not having any contact with these clients to speak of, we thought, well, we can step up and we can have at least individual sessions with clients and check in with them. So our plan is we're basically going back to this hybrid system, probably through the first of the year, and we'll wait and see how Colorado's doing at that time.
And just we weren't having zero contact with clients, Gary. We weren't seeing them in person. So
I know.
we were doing lots and lots and lots of phone appointments, and we're still doing lots of them. So I just want to be clear about that. We
right.
were just off the radar completely. So
I'm sorry, I implied that.
Okay, so I actually think yeah, that concludes our presentation. It's so weird. It's just like I don't even know. I can't see anybody. Is anybody there? No one ever chatted anything, so I don't know if that's necessarily a good or bad thing.
So if you have questions now,
Yeah, if you can feel. I mean, we have a small enough group. You can certainly just unmute yourself, I think, and talk. I just put in our phone numbers and our email addresses in case you guys have follow up questions.
okay, I'm not seeing any.
I know. No one's saying anything.
All right, well then, thank you everybody. I appreciate your attendance. Oh, this is helpful.
That's awesome. Thanks so much, guys. This is Kyle. I don't have any questions. I just wanted to thank you for presenting today.
You're welcome.
Welcome.
Yeah, that may be it. No one's popping in, so I think you're probably good to sign us out.
Okay,
All right.
cool. Thanks, everybody. I'm gonna
Thanks, everyone.
now
Bye.
to figure out how to stop this.
And then Denise, I'd emailed you, but then if you could just send like you said, the PowerPoint when you send the recording, that would be fantastic.
Okay, cool.
And then I'll probably I was supposed to get the course ID for this today, but I think I'll probably get it tomorrow. So I'll make sure you guys get that so you can apply for that teaching credit if that works for you.
Okay, cool. Yeah.
Awesome. Thanks so much, guys.
Okay.
Mhm.
Bye.
Bye.
It won't let me leave. I keep hitting the button to leave.
I know. I'm stopping it. So okay, now I got it. I'm gonna end it for everybody.
Oh, okay.